3, 2, 1. We're live. Over to you.
Great. Wonderful. Hello, everyone. I'm just wondering why I'm not going on the main screen.
Okay. Speak of you. There you go.
Welcome to the webinar today on expert tips on how to settle your tax disputes. And well, I understand, welcome to polling day. So in honor of polling day today, we are going to be conducting a few polls as well, just to keep you alert and engaged. At various times during the webinar, it's just suddenly going to pop up and it might still be there. You are welcome to move it around if it gets in your way and you've answered the questions. So let me introduce myself. I'm Jasmine Nara, or Jasmine for short, and I'm a tax investigation expert. I've been resolving tax investigations for over 20 years, covering all tax areas apart from IR35. My respective colleague is the IR35 expert here, and he is here today. So I was a caseworker, a compliance manager, and an ADR design lead with Hmrc for 15 years. So I will be providing also some additional information and offers at the end, so stick with us until the end. But for now, let me just do the preliminaries and see that all the technology is working out fine, which I think it is. Everyone is muted, but if there are any questions, please put it in the chat box and we'll answer them as soon as we are able to. We'll also put a link into the feedback form in the chat box so you can answer that, and so that we know how to do things better. It's the first time we're actually running a webinar like this from Tax Resolute, so I want to see how we can best serve you and how we can improve things and make it better next time round. So you should already see there's a poll that's gone up where it's asking you, do you deal with tax disputes? And it's just asking basic questions. So for now, what I'll do is I will share the share our screen, my screen. If you give me a couple of moments. Right. Just to fiddle around with my screen, so it'll be this one, share.
That's perfect.
Yeah. And there we go. Which one can you see with the notes?
We can see the notes and the main thing.
All right. Okay. Ooh. Let me just go right back to the beginning. Apologies. So I was going through it earlier on, and there we are. So today you will have seen that these three characters, we had a lot of fun creating these characters, Mr. Orange, Mr. Green and Mr. Blue. So we're starting off with these characters in the scenario, and you will have seen them in our post inviting you all to this webinar today. So we're going to set the agenda, which, as you can see, for the statutory review, we're going to set the scene, we're going to introduce you to statutory reviews and its processes, and also we're going to weave in the case scenarios, and then we'll have a question and answer. I haven't put specific times because I like the process to be fluid, but we are aiming for the last 15 minutes or so for questions and answers. Okay, so you know who I am. So the case scenario here is we have Mr. Orange. This feels really hard done by. He has had the compliance check, and Mr. Green, his accountant, has done his best to provide the information and documents. So, but there's still a disagreement with Mr. Blue from Hmrc and Mr. Orange, the taxpayer. And so in order to bring things to a settlement stage, Mr. Blue has now forwarded a tax assessment, probably because it's gone on too long, and in order to protect their position, they forwarded a tax assessment. And now Mr. Orange has received a tax assessment in the post. So what happens now? So we will now introduce you to the statutory review process. So I'll let Chris come on board and introduce himself to you all.
Hi, Chris Leslie, ex-revenue, 23 years, going on 24 years, left in March 2009. I've worked in the Big Four and also for the last 12 years in my own consultancy. I deal with fraud disclosures, anti-avoidance, commonly referred to as codes 9 and 8, and I also deal with IR35 for my sins. So I'm a bit of an employment status guru as well. So there's my three strands, and that's my areas of expertise really.
And the reason why I invited Chris really was because he's done the other side of when it's got very difficult and it's gone to tribunal. And so he's seen it from the other end of the process. So I thought that was interesting to have his perspective on very contentious tax issues.
Yeah, I'll just add, from about 2009, the new tribunal rules came in. And around about that time, that's when the internal review, now referred to as statutory review, also came in. So it's very much formalised set of steps. So I think that's just sets the scene for this particular webinar.
Okay, so where we are at the moment is Mr. Orange, the taxpayer, has received a tax assessment in the post. Mr. Green, as the accountant, should have received a copy of the assessment in the post as well. The assessment is for a shocking amount of £530,000. Mr. Orange is in a panic, and so is Mr. Green. So now they're wondering, what do we do at this point? So, what are the options available? Well, Mr. Orange and Mr. Green has 30 days to submit the following in writing. They can either ask for a statutory review, that's option number one. Option number two is after considering a statutory review and they reject the offer, they apply for alternative dispute resolution, which is ADR, or they can go straight to tax tribunal or tribunal hearing. And we kind of questioned this yesterday when I was discussing this with Chris, because there is times when you can have an informal option, but with the agreement with Hmrc, when you provide additional information and documents, but the essential thing is this has to be done with Hmrc agreement to safeguard Mr. Orange's, the taxpayer's position for a tribunal appeal. So there has to be a valid appeal in place in writing in order to be able to provide further information and documents. So this is a bit of a grey area, but there must be a valid tribunal and a valid formal appeal in writing submitted. And we've done a diagram, so it just shows quite easily the options available. So Mr. Orange, as you can see, he's received the tax assessment, the tax or penalty, but in our case, it's a tax assessment. He can either go by tribunal or go statutory review. But if the statutory review doesn't work out, you can go to alternative dispute resolution process and then the tribunal appeal. And then the third pathway you can go for ADR, alternative dispute resolution, and then go for tribunal appeal. But I will explain later on, there must be a valid tribunal application put in place. So in order to go for ADR, at this point, you must have a valid tribunal appeal in place, which we will go into further later on in the second webinar. So you should have another poll come up. Do you engage with statutory reviews in your cases? And it's just out of interest we're asking that. So we've talked about the three options. Now let's go in and explain and talk in more detail and define what they are exactly. What does it mean? So what is a statutory review? Well, it's an internal process for HMRC whereby an officer who was not involved in the original decision looks again at the relevant facts and law and scrutinises the casework. And you can see the tax legislation reference there. And the time frame you normally for statutory review is 45 days, but this can be extended by agreement. And we have had in this COVID-19 period where we've extended it by 3 months as a result. So you will get offers at this time, but it has to be with the agreement of HMRC. Both parties have to agree.
Can I just step in there, Jasmine? So the statutory review is a formal process. So usually what's happened is that you've had the inquiry, the HMRC caseworker has reached a decision, which is an appealable decision, i.e. an assessment. You have a valid appeal in place for the postponement application, postponement tax. Then there's the a view of the matter expressed by HMRC, again, it's appealable, and that brings us into the statutory review sphere. And that's the chain, isn't it? And that's the bit that why would we ask for one? And I think that what we really want to do is sort of, get the conclusions crystallised.
Well, I can just give you an update.
Fair to say?
I can give you an update on the poll. 53% of people rarely use the statutory review, 39% sometimes, and then 11% often. So just thought I'd give you an update.
Okay, that's interesting. I mean, the statutory review, as Chris has put rightly, is an appealable decision, and the statutory review, the decision that comes from that, supersedes all previous decision that takes place. So the reason why this whole webinar actually came into being was because I analysed the annual report from HMRC, and I found it interesting because in my case, in my tax disputes, I found the statutory review not to be so effective because I'm dealing with very difficult tax disputes that's reached an impasse. And for me, actually, less than 1% of my statutory reviews have been successful where they upheld the customer or the taxpayer's view. But here, I saw that that about 81% was upheld in regards to the VAT penalties. So where we have procedural matters and smaller kind of penalties, for example, the late filing penalties and so on, it's a much more higher success rate. And where we have other tax cases, then the success rate is a bit lower at 40%. So it is then it did lead me then to go and do my own research, because I found that the statutory review as a statutory right is actually it's worthwhile applying for a second pair of eyes for another HMRC officer to look at the decision. Because the annual statistics, the reports that have been provided by HMRC shows there's on average about 47% success rate for the taxpayer. So this is what led me to go onto LinkedIn, and I did my own poll, and it kind of reflects the success rates for customers. So we had about 60% who do use the statutory review, and about 40% so who doesn't. And that's the other reason why Chris and I are doing this, because we both represent the extremes. I'm one of the 40% who really use statutory reviews, but after analysing the stats that HMRC have provided, I thought, no, I think there is a value in going through the process, and I will explain why later on, why I didn't add, for me, it didn't add value. And Chris will explain why for him, because he was at the other end, and he would recommend always accepting the offer for statutory review. So Chris, if you could explain your view, why you think statutory reviews are essential to the process.
Well, first of all, we're not dealing with a vexatious matter, i.e. a no chance case. We're talking about a dispute where there's a stalemate. So really what we want to do is to better understand and formalise what Hmrc's conclusions are. So that identifies the substance of the arguments, narrows it down, and then have a look at any areas where there's been omissions, for example, where there's been submissions of comprehensive representations may not have suited Hmrc's arguments and been left out. So really we're looking at to narrow down the areas of the dispute so we can set them out and advise the client accordingly on the prospects of success. So, looking for an expectation in a complicated case involving many areas, I think we've got to realise that the expectations have got to be low to say that Hmrc are just going to fold on a case where they spent a lot of time on. That's the three areas why I say that I would always go for a statutory review, and also sometimes I come in on the 11th hour, so I help out in an accountancy firm with a client's dispute, fresh representations or collaboration of evidence needs to be better presented perhaps, and at that point we want to raise the matter, and we had quite a lot of discussion, didn't we, Jez, with this one, whether or not at what stage.
See, my issue is with statutory reviews is the Hmrc review officer is analysing the file, the case, and that case, the way the information is put across is framed the whole case is framed in the view of the decision maker or the Hmrc officer. So what is then analysed by the Hmrc review officer is something that is already framed. So I see it as it being regurgitated. And so instead of having, which I think the officer, Hmrc review officer should be doing, it should be a second pair of eyes critically analysing the whole decision, the whole case, the view of the matter. But what we see is it's being regurgitated, so it's like almost like a tick box exercise. Yep, he's done that, he's done that, he's done that. And so for me, in my cases, I've found that's why less than 1% has been overturned. But my, esteemed colleagues in this area, they have said where it's really, quite glaring that it's a very unreasonable decision that the Hmrc officer has taken. It does help to have that, because in those kind of very glaring situations, it has been overturned, so it's worthwhile. But we will go into, I am being converted, because by all the by the analysis that I've done are presented by Hmrc figures of the statutory review, and by like having these discussions with my colleagues on LinkedIn and with Chris as well, that maybe even if it results in the decision not being overturned, it still does provide value. We'll go more into the whole process, which is right. So, who does the statutory review? It's meant to be an independent officer based in Hmrc solicitor's office. And that may sound a bit intimidating, the solicitor's office, but actually it's you know, an HA or higher officer, normally compliance, someone who's had experience in compliance checks and so on, and an officer who will sits outside now the compliance activity of those who are doing the casework, and they will be reviewing it. But when you get to more contentious views, we found, as Chris has found as well, that when you're engaging with HMRC's Solicitor's Office, it's their senior lawyers, solicitors and chartered legal executives. They refer to HMRC as the client. So the other day, I was dealing with, again, somebody in regards to the statutory review, and he was a lawyer, but he was engaged by HMRC, but even he referred to HMRC as the client. So it did come back to what we were thinking about. Do we really think the office is independent? So my esteemed HMRC colleagues will say, yes, they do work really hard at being independent and providing an objective opinion on the case. But I think from my experience, I haven't really seen that. I found that it's just been regurgitated. But what do you think, Chris?
Well, I'll ask some open questions. When it's undertaken by someone in HMRC's Solicitor's Office and Legal Services Department, that solves, how independent is it? They're employees of HMRC. When representations are dismissed, and I've got to say, well, how is that independent? And I have come across that. Now, everyone's got different views and different interpretations of the fact, of course. And what really counts is having an open mind and applying a balance. The other question I would say is, when it's based on conjecture, surmise or hearsay, then that's not particularly independent. So what's really important, I would say, would be corroborated facts and what the law is, so the case law principles. But the facts are essential, and I think that's the area in where there's always a bit of an impasse. As I say, clarity on HMRC's opinion is required on what they can crystallize it.
I think it's good just to have a summary of the decision, to go through the process. Again, as a reminder, so we've got our taxpayer, Mr. Orange, who's received the assessment in the post, and where you would have, at the end of the assessment, there'll be a couple of paragraphs where they will have the written offer of a statutory review. And that's when you have to write in and say, yes, we accept the offer of the statutory review, or no, we don't accept the offer of the statutory review. So what are the rights? What's your rights, Mr. Green and Mr. Orange? Well, HMRC has to make a written offer of a statutory review. And there was actually a tribunal case on this, the Matiola tribunal case. They had the permission to make a late appeal, which was that was in 2009 the assessment was issued, and it was only, I think, 2019 that the decision was released, the tribunal decision, and it allowed permission to appeal, simply because there was no evidence an actual offer, written offer, was made to the taxpayer for statutory review. So you can see how important it is in the process that we have something like 10 years later on the basis of a statutory right not being offered to the taxpayer. On that basis, their appeal was allowed, a very late appeal. So the other thing that I found as well, that HMRC tends to be a bit quiet about, and you won't see it written anywhere, and they don't really inform you of this, is that according to law, you can make a representation to HMRC during the statutory review. So what normally happens is you get the assessment, you accept you accept the offer for a statutory review, and it's a passive process, then you expect to hear back from the review officer and you wait for the decision. But actually during this period, you can make a representation. So you can actually say, well, we think our decision, in this case, Mr. Orange has been given a £530,000 assessment. We think on the basis of the information and the facts in this case, we don't think that it's reasonable. We think it's a very unreasonable approach to make that you should be issued this assessment on perhaps on the basis of maybe one day invigilation or one single fact or analysis, instead when you've provided this whole picture. So you can actually summarise your argument and send a representation straight to the statutory review officer. It doesn't need to be a passive process where you just wait for this decision to come from the review officer. So that is a tip we definitely can share. You can put this forward. But what you can't do is you can't submit new evidence or information to the statutory review officer. And we found, Chris, this was a bit of a grey area, wasn't it? Because we have found situations where maybe some evidence has been considered by the statutory review officer. And so it depends on a case-by-case basis, really. But the rule of thumb is any new evidence or information has to go back to the decision maker. Now, the reason for this is the review officer has to review the decision. So if the decision doesn't include the additional information and documents that has been provided, it's actually jumped a stage. So the review officer can't analyse something that is not included or considered within the decision. And that is why you will find that if there's any additional information or documents provided, the review officer will say, I can't look at that, it has to go back to the caseworker. And the caseworker then will look at the information and the evidence and then see if it impacts the decision or not. If it doesn't, then as long as it's been considered, then that decision is what the review officer takes on. So that's why you will have this approach from Hmrc. The Hmrc review officer, they won't take any additional evidence or information on during the statutory review process. But you will come across different approaches. So sometimes an Hmrc, and it really depends, it's quite subjective really, it depends on how the review officer looks at the review process. And one officer may think of it as, it has to be a second pair of eyes. I need to look at it and review the whole thing. And another officer may look at it as just a tick box exercise, as in, has the Hmrc officer followed the procedure? Has he done it correctly? Yes, he has, and that's it, then we agree with the decision, we uphold the decision. And I think that's where maybe the issue can lie, in the different approaches that the review officers have.
Could I just step in with a couple of examples, just
Yes,
to
please.
bring life to it, and not disputing what you're saying, Jasmine. What happened is, in an IR35 case, this is an actual case, and what happened was it got to a request for statutory review. I engaged with the statutory reviewer from Solicitor's Office and agreed for further representations to be made, which took the form of a formal report. That report was submitted in ample time. You've got to give them time. And so I've made representations which they must, by the letter of legislation 49E, they must take into consideration. However, the statutory reviewer found the conclusions letter made absolutely no reference to it at all. Now, probably, just bearing out what you're saying there, is that they didn't send it back to the decision maker. So this was back a few years ago. So it's an evolving process, and it's not until you start looking at the legislation and having a look at what they do. Hmrc has, by the legislation, they determine the extent and nature of it as well. So, in another case, I've just recently, last year, the decision was made, assessment was made, say March 2020. I made the representations, which were very detailed, 14 pages, in May. The view of the matter was expressed by Hmrc in June, which made no reference to those representations, and that was from the decision maker. That got appealed against, and then a request for a statutory review to be undertaken, and which was extended beyond the 45 days, twice or thrice. And on Christmas Eve, we get a decision which basically disregards any representations. Now, that was my interpretation on the facts, and Hmrc's interpretation was different. So in those two cases, actually, they did say that they did actually identify the documentation which I made representations on. But in the earlier example, they totally dismissed it. They made no reference at all to it. So that's what I suspect what you're saying. It's quite subjective in between the lines of legislation.
Yeah, I think that is the issue, and that's why you have different approaches from the Hmrc review officers as a result. But I mean, if we look at the reasons why in this case our taxpayer, Mr. Orange, should accept the offer of a statutory review. So we've outlined that you can put further representations in. So it's not just a passive process in order to, that should be taken into consideration, and we will address what happens when it doesn't. But the reasons why Mr. Orange should accept the offer of a statutory review is it provides additional time. So you can, and I think both of us, Chris and I, we have got things last minute. Normally I get a lot of cases that have been gone through a few hands, a couple of accountants and other consultants as well, and I get it at the point of the tax assessment has been issued and maybe a statutory review has already taken place, or it's just come at that point, the tax assessment has come through and you submit an appeal. So the additional time that your office gives you to review the case, if there's any further documents and information that can be provided, and also the possibility of a decision being overturned. As we've seen from the stats earlier on, there's a good chance where it's 81% in regards to back penalties and surcharges, but about 40% in regards to other tax matters. So there is a chance of it being overturned. It's also part of the appeal process. So it's a statutory right, and it's one of you would have to upload the statutory review letter when you're actually applying for a tribunal, when you're applying for a tribunal appeal. So the actual process, when you go online and you put the details in, your details and your client's details and so on, and the grounds for appeal, it does ask you, have you had a statutory review? If yes, then can you upload the statutory review letter? It does actually ask you to do that. So the other thing is the decision, it summarises HMRC's position and it supersedes all previous decisions by the caseworker. So as Chris has said before, this is the final decision that you can appeal against. So anything that has happened beforehand, you don't need to take that into consideration. This is the current decision, the current tax position summarised by HMRC, which you can concentrate on. So for me, it does actually add value in respect of it summarises the case for me. So you'll have it in a few pages, and you know what's happened, and they will go on a chronological basis. This happened, and this is why we don't agree, or we agree or disagree with the whole process. So these are the reasons why a statutory review should be accepted. And we've also highlighted that what else you can do. So instead of being just a passive process, you can put your representation in. But where you've got situations where you feel your representations has been ignored, and the statutory review offer or statutory review letter rather has been issued, you can then go back and underline your representation and say, this is what you put in your representation and this has been ignored, and it will be considered by the tribunal. So you can do that, because this was another point we had, wasn't it, Chris? We've discussed this in the past previously. At any time before a tribunal hearing, we can submit additional information and documents, anything that you think will resolve the issue. So you should be able to do that any time up to the hearing, and if it's even before, a couple of weeks before that, then you would have to get the tribunal judge's permission for any late submission of information documents. But you do have that opportunity all throughout. So even though during the statutory review they say, well, we're not going to consider any additional information and documents, but there is a process there, you have a right to do that. So the issue is when is it going to be considered and who it's going to be considered by, and that's the issue that you could have. So you may have a process where the statutory review has been issued, but it's left very relevant information and documents out. So I had one case where we had an alternative dispute resolution on it in the meeting. One of the first things I always do is highlight, this is the documents that our client has submitted. And I just went, this is document A, document B, document C, and document D. And the officer then went, oh, hang on, I haven't received document B or C. And it then transpired it was because it was sent to the statutory review officer, who did not forward it to the caseworker, so the caseworker couldn't consider it, and therefore it had been left out, and it was not included in the statutory review. So you can have situations like that arising as a result. Okay.
Can I just clarify? Obviously, after the statutory review conclusions that has been received, it's not a roving process. That's it. That's it. And the decision in Mr. Origin's case is still being reduced down to 250,000 in terms of tax, which is still quite catastrophic for Mr. Orange. So it's not just a piffling amount, and therefore serious consideration has to be taken to go informal and bringing the appeals into the tribunal process. The grounds of appeal, I think we did talk about this, and this is about the statutory review, but I think the grounds of appeal, in terms of the continuity of the argument, is the same. Whilst the grounds need to be broad enough, there isn't the opportunity in the T240 to go into particular detail, but the pleadings should be consistently pursued. And when we talk about introducing new documents, be warned that you've got to be very careful not to introduce a new line of arguments. For instance, let's say there's a telephone conversation with Hmrc, with lots of assertions in it and no questions being identified in the document itself. So what you've got is a series of responses, and perhaps to corroborate those responses, and really, be subject to cross-examination on that. So I think that's a sort of an opportunity to really sort of drill down into the granular detail, and that's what we're talking about. Then you will be producing a list of documents, and the documents themselves, and exchanging the ones which Hmrc doesn't have, and vice versa. So it's not. Yeah, we're not giving the impression that you just pull rabbits out the hat at the 11th hour. Got to give Hmrc a reasonable opportunity, and of course the same applies to us.
We had this is the actual legislation here, which is, I mean, we've been tax geeks, really. We found it really interesting, and it kind of, we spent quite a long time just discussing all of this as well. So you can see in section 49E2, which is it outlines from section 49A to F, outlines the rights for the statutory review and the processes and so on. But we found this section particularly interesting because it says in section 49E, the top bit, number 2, apologies, the nature and extent of the review are to be such as appear appropriate to HMRC in the circumstances. So we found that quite interesting, the way that was put across. But if you go further and have a look, because it refers to subsection 2 here, for the purpose of subsection 2, HMRC must in particular have regard to steps taken before the beginning of the review by HMRC in deciding the matter in question and by any person in seeking to resolve disagreements about the matter in question. So what that is saying in kind of plain English is HMRC must take into account all the steps, all the facts and information by both sides, not just HMRC, but also the other party, the appellant or the taxpayer, and they need to be able to demonstrate that. In how they brought it into their review and how they've considered it. So there's actually been a tribunal case regarding this point, Angel Beauty Parlour, and in there the tribunal judge actually refers to this in that the HMRC review officer had not actually critically analysed anything. So they didn't analyse the methodology. It just hadn't been critically assessed or reviewed. It wasn't done as a second pair of eyes on the decision. And the only any kind of review that was done was where the review officer said this is this is the best judgment, and that was it. So I mean, even the tribunal judge pointed out that wasn't enough. You needed to take a further step to analyse exactly how had HMRC had reached their decision, and how and whatever steps the appellant or the taxpayer had taken in order to reach a settlement about the dispute in question. So that was interesting, and we found the nature and extent of the review are to be such as appear appropriate to HMRC in the circumstances. So you can see this is where again the subjectivity comes in. So how far and to what extent is the review going to be conducted, and that actually puts the ball in HMRC's court, because they're the one who decides the nature and extent of how far they're going to review the decision. Do you have anything to add to that, Chris?
Yeah, the consequences of that. Because I'm not. I think in HMRC's defence, that's what the legislation says. They determine the nature and extent of the review, but at subsection 4, as we see at the bottom there, must take account of any representations made. So if they don't, then perhaps that's what led to the Angel Beauty Parlour cases, the judge's concerns. So, yes, I think that a statutory review, why do it? Well, we want to crystallise what HMRC's position is, and also then look for any gaps, holes in areas where the representations have been interpreted in a different way. At what point do you take counsel advice on it? I would say that when it's great sums involved, then you need to have a second opinion, and which I've got 3-4 cases at the moment one of which is involved with council. On other occasions, I don't. It's not just a straightforward matter. So the nature and extent, not necessarily just of the statutory review, but of the case in itself, and what grounds of what the pleadings are, what the prospects of success are.
But this is what the judge will look at, and this is the section of the statutory review that you can use. We can all use in approaching the statutory, the review officer. In this case, what needs to be considered. But you can see where the subjectivity definitely does come in how it's being approached. But again, we can put forward, if we think there's been anything being ignored in the decision, in the review letter, it's definitely something that a tribunal judge would consider. Okay.
And it's just the overriding objective, of course, is a just and fair process.
Yes.
So we're coming to about 15 minutes of Q&As.
So if we just, I can't actually see the chat box, which is a bit difficult. Let me just see. So we've got this situation where Mr. Green has submitted further evidence and information to Mr. Blue, not Mr. Blue, for Hmrc after further discussions with Mr. Orange. So poor Mr. Green has been going to and fro between Hmrc and his client. So Mr. Green has also submitted a representation to the review officer using the information and documents submitted so far, and the statutory review has reduced the tax assessments based on the representation to £250,000 as a result. But Mr. Orange does not agree with this figure and is unhappy with the outcome, and he does not think Mr. Blue from Hmrc has listened to his account. So that's where we are with the scenario. So I can't actually see the question and answers, Gary.
I'm happy to WhatsApp them to you or email them.
Yeah.
But if you look at Q&A or chat, it's all the questions are in there.
Yeah, I can't actually see them.
Okay, I'll send them to you, no problem. And by the way, guys, this is very, very informative. Really, really beautiful presentation.
Where is it? So far we've got, do you engage with statutory reviews in your cases? And it's often at 15% and sometimes at 40%. So can the questions that we have, can the officer request further information during the statutory review if something is not clear to them? And that's from Hmrc Gohill. So can they request further information during the statutory review? Well, the rule of thumb is actually that the decision maker in this respect would have to consider that information first in the decision, and that's how it's being put across. But I would suggest if the review officer is asking for additional information, then surely, that's a good point. Rather have them reaching a conclusion. He's obviously considering it. They are obviously considering it further and giving the opportunity to your client and yourself to provide further evidence. So it's not normal. It's not the normal procedure, and I think it shouldn't really be done within the process. But if the review officer does allow leeway, then I would say why not? In that case, why not? But if it's a situation where you think you've given a lot of information and documents and it's now becoming very onerous, how much more are you going to provide? Then you don't need to. You don't need to provide that information because you think that's enough information to provide. We don't need to go any further than that. What do you think, Chris, on that question?
I would say the statutory review needs to be looked at from a decision maker's point of view. The statutory reviewer, if he comes across something, let's say the statutory reviewer's experience and comes across suspicions of a tax fraud. What happens if the statutory reviewer comes across where they haven't sent out the fact sheet on penalties and human rights, Article 6, and not to self-implicate, and there's something a little bit more that met the eye. I think I've never come across that, I've got to say, and as a experienced advisor, we would have considered the Code 9 work beforehand. But I would just say that, and what happens if the statutory reviewer thinks, well, actually there should be a different schedule of charge, and barking up the wrong tree, but there is something wrong here, and sends the officer back to go and make fresh assessments. That has happened, by the way, and it's in a tax case I've won. But it's these are exceptional areas. Usually, and I've got to say, in my experience, when it's been more of a complicated case, they'll find for themselves, and base it on whether or not they followed the correct procedural guidelines, etc.
I think because each kind of tax dispute is different, and you have to judge it on the merits of that tax dispute. But so you've got like 3 different perspectives here. So you could have one where it could be indicative of another argument being pursued, and they are collating information and documents to pursue that argument. Then in that case, it's not in your interest to provide that information. You would need to know why exactly that information is being requested. So the second one would be, the second perspective would be, yes, if it is to clarify a point that gives you an opportunity for it to be considered as a whole, and you think it will be beneficial, then yes. But on the other hand, if you've provided a lot of information already and you think it's enough to demonstrate the point, then you don't need to provide it because it's becoming onerous at this point. So it really depends on the actual tax, technical tax point that is being disagreed upon. Okay, another question is, another reason to accept a statutory review is because the client is reticent to go to tribunal and insist you explore all other avenues first. So client pressure is important when they are paying your bill. Yes, again, we agree. And as you can see, I've done a complete, I was from very anti-statutory review. I thought for me, I thought it's a waste of time, really. I just wanted to go and settle the case, and I used different means to do that. But as you've, as we've seen, it is worthwhile, and it does give you additional time, and it does give you another pair of eyes on it. Whether it's effective or not is another issue completely. But why not? It's a process that doesn't incur really any additional costs unless you're making a representation. So if you are putting representations in, then it will incur further costs in that respect.
Of course, if I can just step in as well, there is always the opportunity to settle by agreement rather than go down formal lines. There might often is termed as a pragmatic settlement, and it might be viewed that the costs of taking it to the case to the tribunal are relatively massive, and so that might form the decision as well. The client has to be well briefed, has to know what is going, which route to take, because once you step into that statutory route, you're into the tribunal proceedings if you don't agree, and if you don't respond within 30 days to the conclusions letter, it's settled by agreement by default, so sections 54 TMA kicks in. So I do think that there is an opportunity to say, yes, whilst we appeal and we disagree with the conclusions, perhaps this then opens up the ADR route, really, which is going to be the next part, the webinar, isn't it? That we have got this information. This is the interpretation. We've corroborated the facts, and it has been excluded from the conclusions letter.
So I've got one more question for you. You'd be in a better position to answer this because you've dealt with contentious issues at tribunal. So at what stage would you take consul's opinion on the case? Before or after statutory review?
That's a difficult talking question. I think that I hate to say each case on its own merits, but if it was a massive case and it was at very highly technical points on interpretation and going against Hmrc policy, then perhaps that is the time to take counsel advice, a second opinion. I have done as well. I have done during proceedings as well, when there's been a request for formal written submissions after the end of them. But here what you're saying is before the statutory review?
Before or after, you were saying? I
would say, unless if Hmrc's arguments are totally wrong, or if there's no crystal clear case law on it, I think, but a counsel opinion, Hmrc opinion, or opinion by Chris Leslie, it's not the matter. It's what the judge's opinion is based on the facts in the case law. So counsel opinion on a very experienced counsel who's got a lot of experience on the subject would be valuable, and probably add to the case.
I've actually, I do work with a tax barrister, and on my cases, when I've needed a second pair of eyes, I have actually gone to him. Actually, we are going to do another webinar, so he's going to do one with me on tribunal side, tribunal hearings. So he's very experienced, and I do tend to go to him. Like the other day, I did actually say to him, what do you think about this, Julian? Do you think it's worthwhile going to tribunal, even before the statutory review? I have to admit, I haven't actually given maybe the value that other people have to statutory reviews. I have come across where the caseworker has said to me, well, we've had the statutory review and it upheld the decision. And so that argument doesn't, they see it, Hmrc tends to see it as a way of endorsing their decision. And for me, it doesn't add value for me. So, but what does add value is if I have someone like another tax barrister where I say, well, what do you think should I do? I'm thinking this, and this, and he says, well, yes, maybe you have this, it could have this impact, this impact, this impact. So in that case, when it comes to consul opinion, it is useful, but at the end of the day, I have to agree with Chris. At the end of the day, when you go to tribunal, it's the judge's opinion that counts more than anything. And so there's no guarantee what the consul's advice, whatever they recommend, that it's going to go that way. Sometimes it's very hard to predict which way the tribunal judge is going to go, because again, it really does depend on a lot of facts, the oral evidence, how the appellant put themselves across, how you put yourself across as representing the appellant as well. So a lot of other factors does come into it on the day.
I'll also say that my company name, Tax Networks Limited, is not by accident. I've got a network of advisors, so you're one of them, Jasmine, that we will discuss matters behind the scenes and share their experiences, which are invaluable. So I think that that's an important aspect to demonstrate that your nose is not too close to the client window type of thing. To get it, look for an independent position, not confirmation bias. Not say, oh yes, of course you're right, and all this. A good critical assessment, and then basically that's what we're doing with council. It pays on its own merits, but you wouldn't be doing it if it was £100 penalty.
No. We have another question, but it kind of comes out completely of the statutory review. So we have Adr Ismail who's asking, have you experienced limited companies operating from a personal bank account, and how did it pan out explaining this to Hmrc? So it is actually coming out of the theme for statutory review, but I think, and no doubt, I think I can answer for Chris, yes, we have experienced limited companies operating from a personal bank account. And the rule of thumb is any bank account, even if it's not in your name, that you use in order to pay for your company expenses or receive income is deemed as part of the company records.
Yeah, slightly records. And that covers the question. I think the first question is 409 by anonymous attendee. What happens where Hmrc is paying, as he says, playing hard and fast with the law? For example, when Mr. Blue has requested full bank statements at the first stage of a compliance check. So if the company's been operated through a private bank account, I think that answers the question on that one, really, doesn't it? Unfortunately, it's a static record, and really you'd have to demonstrate with critical analysis.
In the interest of time, and we want to run like a Swiss clock over here, there is a handover. We're gonna be going over to Jim. It's 5 o'clock, and wow, the engagement from everyone coming in has been absolutely fantastic. So many questions. Jim, do you wanna put your camera on and tell us, has that been as fascinating for you as it's been for me?
I'm on. It has indeed. Very interesting listening to that from, dare I say, the other side to where I am. Do you wish me to introduce myself before we move on?
Yes, please.
Hi everybody, my name's Jim Benson. I work in Hmrc, and essentially I lead the alternative dispute resolution team. Prior to that, I was a manager of litigators. Before that, I was a litigator myself, and before that, I actually worked in the old large and complex team, mainly looking at corporation tax inquiries with a little bit of income tax thrown in there as well. So I've been in Hmrc and previously the Inland Revenue for 33 years now, crikey, man and boy. And my current position, I must admit, is a job that I thoroughly enjoy, and working in mediation is something that's relatively new to Hmrc, and something that I'm hoping after this talk we can persuade you to consider moving forward.
Well, the reason why I've asked Jim to come on board is, look, let me go back, it's getting there. I'll go to this. Well, I was discussing earlier on about the 3 options that you have. So in this case, because I could have easily done another webinar on tribunal appeal, but in the case of, in the interest of not exhausting everyone, I kept it to statutory reviews with Chris and alternative dispute resolution. Jim is, as the current ADR Assistant Director, and someone here who was involved in the setup as the ex-ADR design lead between 2012 and 2014. Who better to come across and get that expert tips? You can't come across anyone better than us two, basically, in this area. And you definitely have the inside track, and you're in a really good position and have the opportunity to ask those difficult questions. And believe me, I will be asking some difficult questions too in this webinar. They're straight from the horse's mouth. You can ask us. So it's a great opportunity. So we've received the tax assessment penalty, and the statutory review has an offer. The taxpayer cannot request it. It has to be offered by Hmrc. But you can point out, if you haven't received the offer, you can actually say, wait, I have not received an offer for a statutory review. But it has to be put in writing by Hmrc. So if that has not worked out, then you can go to alternative dispute resolution. Before, what I was doing was I was registering the tribunal appeal first, and then I went straight to alternative dispute resolution. So Mr. Orange has received the tax assessment in post, goes to Mr. Green, his accountant. They accepted the statutory offer, but it's not helped to that extent. So what next? Okay, so what is alternative dispute resolution, or ADR for short? It's the procedure for settling disputes without litigation, without going to the tribunal. So under ADR, both parties, Hmrc and the taxpayer, agrees to bring in a third party. So in this case, it's Hmrc mediators to facilitate an agreement. So the process of mediation. So it's meant to be the mediators are meant to be independent. So I'm sure you'll ask this question quite often, Jim. How are Hmrc mediators independent?
A very good question, and one that we are asked a lot. And the only answer I can say is the proof in the pudding in the eating, in the fact that certainly when ADR was first set up, there was always going to be the question of independence. So we are very, very open with our staffs. We actually still ask for feedback after every mediation, and the question there, for example, some of the questions are you satisfied with the ADR process? Would you recommend it? Has it improved the client's experience? I have given various presentations to the likes of CIOT and the Institute of Chartered Accountants of England and Wales, where I specifically asked for feedback with regards to are the Hmrc mediators seen as independent. I chair twice yearly a meeting with essentially external stakeholders, CIOT, ATT, barristers, a couple of judges who actually appear in a personal capacity, Citizens Advice Bureau, etc. All the questions that we always bring up is, how are we seen as being independent? If we have any queries in relation to independence, we do look at that critically. And I think, to come back to it, in the last few years, I do keep an eye out on the articles that are written in various accountants and external journals. And one thing that I'll be very pleased about is that actually they've all made reference to how independent Hmrc mediators are, despite working for the department.
Okay, so what training does the Hmrc mediators have?
They all have external mediation training. We have two firms that have been involved over the year, the CEDA and TCM. So it's an external accredited mediation course that all mediators undertake.
Okay.
So it's not internal training, it's actually external mediation training.
And do you think there's any conflict of interest? Because it's Hmrc mediators that are mediating a tax dispute with Hmrc party on one side.
No, I don't actually. If anything, we've had more criticism from HMRC as being seen as almost too much on the side of the taxpayer, where we see ourselves as fully independent from both parties. We treat both parties equally, and indeed, we do have quite a lot of unrepresented taxpayers that will apply for ADR, in which case we'll double up the mediation, essentially have a friend in court for HMRC and a friend in court for the customer, so we do try and keep that independence as far as possible. And if I decide I'm not paying both for one reason, we are just as critical and can be just as firm and often now with HMRC as the other side if they're not agreeing to any timetable or providing what is required in advance of the mediation or indeed during the mediation.
Okay, and as an example, I've had mediations where the ADR mediator they always announce if they know the caseworker. And there was one, there's been a couple where the mediator, as I'm ex-ADR myself, have had to say, I know Jasmine and I also know the caseworker, and they will announce that up front and say, I do actually know, and it will be in the first phone call by saying, I do know this caseworker, we do actually work in the office, but there's no conflict of interest. But it's at that point where you can say, I don't feel comfortable with this, and if you want to request somebody else.
I've just looked at my diary. My morning is free, my afternoon is free. The afternoon is crazy
if they feel
busy.
there's a conflict of interest, they'll let me know, or when the managers know, and we'll just give it to a different mediator.
Okay. So that's why I wanted to put that across, because it may seem to some that there is a conflict there, because it's an HMRC mediation service that is mediating a dispute between HMRC and the taxpayer. Okay. Yes, and tribunal judges like it too. They actually they encourage ADR, and it is in the tribunal rules and procedures. They say the tribunal should seek where appropriate to bring the attention of the parties the availability of ADR. And in one tribunal case, it does say in Sterling Jewellers, because things were in such a state in that case, they said if ever there was a dispute which cried out for a determined attempt at alternative dispute resolution, it was this one. So the tribunal services and judges definitely does endorse the use of ADR. Last year, to the extent that there was a judicial statement produced, isn't it? You worked on that, Jim, with the tribunal services.
Yes, this was Judge Greg Sinfield, the president of the First Aid Tax Tribunal, who called me down for a meeting in December 2019, only to be met with him and 5 other judges who were giving examples. I thought it was quite ironic because they're all anecdotal from the judiciary, of cases that they had seen coming through to litigation that they felt could and should have been, if not resolved, at least clarified by the use of mediation. One example being, Brexit said it was a beautifully executed case by both parties with regards to the technical interpretation of a lease agreement. Unfortunately, both parties were working off a draft lease agreement and nobody had ever seen a signed final lease agreement. He said, bring this into mediation. Yes, you probably won't settle the argument, but at least you'll be able to get all the evidence available for the tribunal. Sterling Jewellers was touched upon. So my request, I said, well, yes, we know it's in Tribunal Rule 3. Is there anything that can be done that can highlight this more? And this ended up in a working group with myself and a couple of colleagues from ADR, the judiciary, and I'm sure I'm working with people out on this one, which I apologise for, our solicitor's office, COT, ATT, and barristers in essentially drafting the practice statement that went out on the 20th of June 2020, basically saying consider mediation if your case is in litigation and has been categorised in either the standard or complex category, which is where the vast majority of the disputes that would be suitable for mediation by anyway.
Okay, so if we go on to the next slide, this is the ADR process. So this is what happens. You get the tax assessment, it's been issued, and in that same paragraph, at the last paragraph where it points out your options, which is either to go to tribunal, offer of statutory review, or you can apply for alternative dispute resolution. So it will be there. So the appeal has to be accepted by the tribunal before applying to ADR. And we will go into reasons for that a bit later on. So it's an online application, just like the tribunal application. It's online, it's quite easy, nothing difficult about it. You go on, you put your details in, or you need to find it, you just need to Google ADR Hmrc and it will point you to a page. There's the link. It takes you to online application. You put your details, your client's details, and the grounds for the tax dispute. And once that's submitted, you get an acknowledgement and you get an email acknowledgement into your email inbox. So when that's been received, you've got an acknowledgement straight away. The application form had been submitted. Then an ADR mediator is allocated to your case, and it will be an ex caseworker, so they will know about the compliance. They'll have a compliance background. It may not necessarily be specific to your case, because the whole idea is not to come in with a view of technically addressing all the points, but to come in as a mediator. So they're trained in mediation, as Jim has already said, and also they have training in the tribunal processes. So they will now, the ADR mediator will have conversations with both sides, with the customer, with the taxpayer, and with Hmrc on the facts of the dispute. And within 30 days, they will see if the ADR application should be accepted or rejected. So you get an acceptance. Hopefully you should get an acceptance, and we'll give you tips about that as well. And then a date will be set, and the mediator will ask you for an opening statement, and then you'll either have a face-to-face meeting, or you can have it by phone or virtually online, and it depends on the complexity of the case. Decision makers has to be present. So the people who will sign off on the agreement, so it will be the caseworker and their manager, and it will be the taxpayer and their agent if they're represented. And normally it's one day for the meeting, and then you have an exit agreement on the same day. So everything is geared to resolve the dispute in one day. So from start to process from the start to the exit agreement, it takes they have to finish it within 120 days. And most of the time is like the 30 days where they should reject or accept, and then the next time-consuming process may be just arranging a meeting, because it takes time to have put everyone together. But the actual mediation process takes place in one day, which is why I recommend it myself. So how can it work for Mr. Orange and Mr. Green? So applications are accepted when, for example, the progress in your case has stalled and Hmrc are simply not listening, which is what Mr. Orange thinks, that Hmrc is simply not listening to him. When the dispute is going in circles and both sides are entrenched in their position, when Hmrc are not giving facts or evidence the weight that a tribunal judge would. And as we discussed in the statutory review, there's times when information and documents either you feel hasn't been given that weight or consideration, or it's been left out. You don't think it's been actually included in the consideration of the decision maker, which is the caseworker, or even or the caseworker or the customer or on both sides, basically. Sorry, a message popped up, which is why I got distracted. And when relationships are strained or communications have stalled. So I have had this. I've had clients come to me and say, we don't want anything from HMRC. We don't want to talk to them. We don't want any communications from them. Or you could have situations where it's a mental health issue that is detrimental to their health, and you can't afford to have that, that direct interaction. So you have situations like that. So in this case, Mr. Orange and Mr. Green, they feel HMRC is not giving weight to their information and documents, and they feel HMRC is simply not listening to them. So the reason why I haven't really gone into why, which areas ADR will not be accepted for is because it's a mediation process, and you have to see in which situations and which disputes the mediation process is appropriate for. So, for example, if it's like a request about time to pay, debt management issues, £100 filing penalty, small penalties, these are issues that the HMRC simply is going to say, or the ADR team, it's not cost effective to pursue, especially when there's so much resource, you're committing the whole day towards resolving this dispute. To resolve the small £100, it doesn't make sense. So in that kind of situation where pay-as-you-earn coding, procedural matters, that kind of case they wouldn't be involved with. Where there's a technical line, a red line that HMRC, units of expertise has said to the caseworker, this is it, you have to stand by this. There's no flexibility here. Then the ADR mediators would have to stand by that. There's no negotiation, because this is what, for HMRC, this is a red line, they can't cross it. So there's no flexibility in that position. Additionally, where there's clearly scenarios where the parties fundamentally disagree on the interpretation. So this is what I was saying about the red line policy. I had an interesting question today, Jim. Can ADR be used in the tax avoidance cases and the loan charge cases?
In very limited circumstances, because it almost comes back to this red line. HMRC will view there as avoidance that requires litigation. So we wouldn't want to get involved in the litigation, or indeed the fallout, if there are then, want of a better term, followers. However, if there are different facts that may come into play with regards to whether the client acted deliberately or carelessly from potentially a discovery point of view, we will look at them. But generally, these are red lines where a decision has been made, and there's nothing really to mediate, because a mediation isn't going to change the view. Certainly, something that's gone through litigation and a knock-on effect to that, or indeed cases at HMRC are looking to get a lead case and litigate accordingly. However, we will still look at the applications. If it can be shown that there is something that does separate this case from the majority, then an application will be looked at. And we've actually had success in some cases, and I don't know where the breakdown in communication on whose side it was an avoidance scheme, but after going into mediation, the customer actually accepted HMRC's position, and they felt they had never been explained to them why they ended up in this position. So we can sometimes add clarity to cases, but the fact whether we actually be able to walk away with full resolution is unlikely, because of course certain cases have got to be litigated. There's a knock-on effect of the litigation, and I think some of the questions there, although the mediator doesn't take ownership of the dispute, that remains with the case team. Any agreement reached still has to be LSS compliant.
We will go into that. That is coming.
Right. Sorry, I've jumped the gun slightly.
Hi, Chris.
Are you referring there when you may step in, where it's particularly sort of procedural matter, a notice hasn't been served, not actually the substantive dispute?
Yes, it's sort of around that area, or somebody may look at their circumstances and say, but mine differ because then we could consider it and see if they do or not. But the actual substantive issue, we wouldn't get involved as to the whys and wherefores around the alleged or proved, whatever term we want to use, actual avoidance scheme.
Again, we will be sharing information that you won't see in any other webinars, and that will come later on. So, in which situations would we use ADR? I mean, ADR tends to lend itself, I found in my experience, in small and medium tax disputes better. In my experience when I was with Hmrc, the large and complex cases, because there's such a huge number of stakeholders, and each area, technical area, you will have someone, an expert on Hmrc side for each section. And then you have on the client side, you may have like a couple of agents regarding that as well. And so to get everyone together to agree, that can kind of be unwieldy. But that's why I tend to find for kind of SME area, business areas, tax dispute just lends itself a lot better. Each case is judged on its merits. Again, one case may be accepted, but a similar one may be rejected. And that's why I haven't given you a specific list that is not applicable in this, and this area, because it really does depend on the case itself. So you could have actually a red line policy case, but there's an area there, a grey area there that can be explored. And if you put that across to the ADR team and explain that, then it could be, and it has been in the past accepted into ADR. But then you have to put that across. So one of the feedback that I have, or questions that I've been asked, and I'm going to ask you, Jim, is why does Hmrc not accept ADR at statement of case stage?
The simple answer is that it does. ADR can be accepted at any time in the process. For a while, there was a change in strategy that once the statement of case had been served, the application for ADR should have been made earlier, because you've got the time spent by all parties in preparing for the tribunal. The tribunal itself may have got a hearing date set and judges already appointed, which could then mean cancellation, because when a case comes into ADR, there is a stake in the tribunal. However, taking account of feedback from our external stakeholders, this has changed. And essentially, ADR can be considered at any stage during the tribunal process. The only caveat to that is, if a hearing date has already been set, then we will not get the 150-day stay that normally comes with an ADR application. So essentially, we have to work that ADR within the time frame. And I've got one of my mediators who is dining out on this, and think will do forevermore, where the application for ADR came in 10 days before the hearing, managed to get everybody together and get a full resolution the day before the case would have had to go to tribunal. So it obviously the sooner the better, because that did put unnecessary pressure on all parties. But yes, we will consider ADR at any stage during the tribunal proceedings. And indeed, if you take it the next stage further, we've certainly seen situations where ADR hasn't been considered or applied for, where a judge has actually said, could you consider ADR? I think the most extreme case was when somebody actually turned to a hearing and said, we'd like to consider ADR. They never put the application in, the judge still gave them a stay in order for us to consider whether ADR would be appropriate. If I can just pick up on one point, and again, I'm going to blow our trumpet here, we are finding that we are getting some success in the larger cases. The very first case we ever undertook via video mediation, which was new for everybody, there were 12 separate stakeholders on video from 12 separate locations on a complex case, and we got a full resolution on the day.
Jim, I didn't say it doesn't happen. I didn't say it doesn't happen. I'm saying that the small cases lends itself better to the process of large, complex cases. So I'm not saying that it doesn't happen and it's not worthwhile applying for. Definitely not. Okay, if we go on to, there was actually something else, but I think I'll say it now. The reason why there has to be a valid tribunal appeal put in place, so you've got the assessment and you need to then, with ADR, apply for tribunal, which you don't need to do for a statutory review because that can come afterwards. But in the process, it's because if an ADR application goes through and the appeal, the tribunal appeal is not valid, and there's no live appeal, then there's no point doing a mediation on something where the appeal is no longer valid. So, because ADR is a voluntary process, it's not a statutory right at the end of the day. And so, when I was involved back in between 2012 and 14, it was like how it was now. It could be applied at any time. There wasn't any barriers to that. And so we even had a case where the tribunal hearing took place, but the judge then said the tax has to be quantified, and it went back into ADR to quantify the tax. So even post tribunal hearing, it had taken place. But I reckon something must have happened, I think, in between, where the ADR mediation may have taken place, or there is application, and then they realised the time for the tribunal appeal had run out. There wasn't any, it could have been done, I don't know where, but an experience like that probably happened, which impacted the process, which now has resulted in there must be a valid tribunal appeal in place before you apply for ADR. And then and then once it's accepted into ADR, it's actually the tribunal caseworker for Hmrc then will apply for a stay of proceedings. So the clock starts ticking. Okay, so what's in it for Mr. Orange, the client? I mean, why should he bother applying for ADR? Both parties retain their ownership of the decision, so the ball is still in both parties' court, whereas with the statutory review, it's the statutory review officer who has the ultimate right to make that decision. But here, both parties still have an opportunity. It enables parties to begin or resume negotiations when direct negotiations have stalled or are at an impasse. A third party presence changes the dynamics of the dispute and brings a fresh perspective. It's a confidential and without prejudice process. If litigation is unavoidable, it can help both parties prepare the facts of the case, and it's savings of times and costs. So this may sound like just a lot of words that we're saying. Basically, the ADR process it puts everyone on the same page. The aim is, at the end of the day, to reach a resolution. The best way, everyone comes in with that motive, and the mediator, it's the job of the mediator to go to Hmrc and go to the agent or the client and explain the ground rules. So everyone comes in with the intention of reaching a resolution on the day. So you have a shift in the attitude there. So if you have a meeting outside the ADR process, well, the compliance caseworker is going to think, has to demonstrate their case and the facts of their case. So the motivation there is of different. There's the different motivation there. Rather than when you come to ADR, the whole point is everyone needs to work collaboratively in order to reach a resolution. So that's the first thing. So second thing is you have a mediator that comes in, so you have another perspective, and that really does change the dynamics of the dispute. It's not adversarial. Let's put it that way. It's not an adversarial environment. And so it really is a process where you sit down, you have HMRC across the table, which I show here, across the table, and everyone is sitting. When we had the days when we had face-to-face mediations, so everyone is basically talking to each other face-to-face, and it really does bring a different dynamics to it. It's very hard to be negative, disrespectful, rude to each other in that environment when someone is sitting right in front of you like this. So it does bring a different environment, completely different environment to the whole dispute. And it's face to face. So like Jim was saying, in one of the ADRs, they were saying no one had explained to the client. They didn't explain it that way. Well, here's an opportunity to put across the information, put across your documents, put across your oral evidence, put across your views, and vice versa. So, and it really does change the dynamics when you have that face-to-face meeting and you have a mediator involved. So, okay, why use ADR? So the stats has been done on this. So you have an average of 15 hours of HMRC time, not just HMRC, but also on our side as well. It's about 15 hours as well to resolve the dispute compared to a tribunal 100 to 250 hours. I see it as the last best opportunity to reach a resolution on this case. It allows for flexible discussions to take place that could not in the normal compliance case process. And over 80% of ADR disputes either are fully or partially resolved. So in my cases, it's about above 94%. We reach a resolution rate for ADR. And I will share again those tips why I've got high figures for that and how I achieve it. So 17 to 25% if you compare to tribunal, the success rate for appellants is actually from 17 to 25%, and that is between 2015 to 2020. So Jim, this is a question that's been approached to me because there's been a lot of agents out there who have had a bad experience with ADR, and they think that ADR is a waste of time. Do you think it's a waste of time, Jim?
I think you know what my answer is going to be. No, in relation to this. I think the results speak for themselves, but there will be situations where even after I've had the mediation, the case might not necessarily resolve, and sometimes I think it might need to be managed expectations that we hope to get a resolution in ADR, but this might not always be the case. And if I can pick up on one of the Q&As there about intransigence on behalf of certain inspectors, I'm not going to lie, the answer is yes. There is also intransigence, unfortunately, on behalf of certain agents when they attend the ADR process, and it's something we are working on. Internally, within HMRC, we are, as far as possible, undertaking road shows to caseworkers to explain the ADR process, how it works. This has been ongoing for a number of years, and we've now actually prepared some videos to show a fake mediation from start to finish. This simply come online recently. And externally, there are occasions where I might have to phone up an agent and say, come on, we're not getting anywhere with this, you know, we're in to take a step back and think, is this the best way to conduct a meeting? So I'm not going to sit here and lie and say it's perfect, because there is intransigence. It's something that we keep working on for both sides, because you're not going to get the resolution. When we kept on words here, you're not necessarily going to get a resolution if you are in the I'm not listening position, or indeed if you come across aggressive, because you're just not going to get open and honest conversation going.
I think that actually harms the process if you come in an aggressive attitude. It's not going to work. The whole point is it's meant to be a collaborative effort. So absolutely. Even when there's situations where you don't reach an agreement, I've had one case where we didn't reach an agreement on the day, but we did 9 months later on. And that was simply because and this helps being ex-ADR and ex-HMRC, because I knew I can ask the ADR mediator, can you keep your hands on this process and ensure that the deadlines are being met and HMRC does what they're supposed to do and what they've agreed to do. So even in the exit agreement, we put in that this additional information or documents need to be provided even though we haven't agreed, and HMRC needs to review it by this time and this time and this time. And so the mediator made sure that process was followed through. It took 9 months, but all of the assessments were withdrawn. All of the assessments were withdrawn as a result, and that was simply because ADR was involved. The other view is that ADR incurs additional professional fees. So agents feel that this is going to incur additional costs for them. They prefer just to go straight to tribunal. And in fact, that's quite similar to what the caseworkers have said as well, isn't it, within HMRC? That's been the resistance from them. Yeah. Why do we need to go through ADR? Let's just go to tribunal. There's already a formal process in place. If the taxpayer doesn't agree, let's go to tribunal. What would your answer be to that, Jim?
Facetiously, it's not really that. So have you ever been to tribunal and cross-examined? It's not a nice experience, to be perfectly honest. My view is always that the tribunal should be the last port of call. It's not a pleasant experience for any party that has to attend tribunal, especially if you've got to be a witness. Think about also for the knock-on effect for the taxpayer and the not only additional cost, but the additional time this is taking. Think about it from your own point of view as a caseworker. If you can get a case resolved quicker, easier, and put to bed, for want of a better term, you can move on to other cases, and you're not then having to do the work that is involved, because for both parties there is so much work needed for the tribunal. When the ADR, I'm not trying to belittle the amount of work that's needed, essentially we're looking at opening statements and having the collaborative discussion. No witness statements need submitting and having to be prepped on the witness statement, having dry runs of it, then be available in court for a number of days. So it's just, personally, I think certainly having a litigation background, a much better way to resolve disputes.
Okay, so this is the key thing that all agents and not even all HMRC caseworkers does not have a full understanding here. And there has been times on HMRC sides where we have had to educate the caseworker that, this is the litigation and settlement strategy. But the litigation and settlement strategy is something that's been produced and published by HMRC, and it states this: it underpins HMRC's approach to tax disputes. So this is guidance that all caseworkers have to adhere to. And I see it as well that I have to adhere to this. So this is always foremost in my mind, the way I conduct my cases. So the whole point is HMRC aims to support customers to get their tax right. So yes, we may have disagreements, but why do we have disagreements? So to resolve those tax disputes which do arise in a way which establishes the right tax due at the least cost, and ADR definitely doesn't meet that criteria in the mediation process. We've already shown in the stats that the cost incurred is much less than what would be incurred at a tribunal. The other thing that is written down in the litigation and settlement strategy, the LSS for short, HMRC will be non-confrontational, will work collaboratively with customers wherever possible. Okay, and where it's applicable, we can explore a range of possible right answers. That's in the LSS. So we're talking about grey areas where you can see there's possible answers there, and they may be correct because it could be an estimate, it could be lack of records and so on, it could be a lack of accuracy. There's many different ways, and you're doing your best, both sides, to reach the right tax position. but it doesn't mean it's just one single answer. It could be a range of possible answers in this situation. And that's why we don't have a one size fits all with ADR. It's a mediation process that has to be applied. So, and also think about when you go to tribunal, again, it's got to be reasonable and a balance of probability that that tax position is correct. So that's what they will look at. Is the probability weighing on your side, your client's side, or HMRC's side? And you have to be reasonable. You need to make all efforts to be reasonable. And the ADR process and the agreement is all guided by this. And not just the agreement, but our casework as well. Our tax disputes is all guided by this LSS strategy. If we go to expert tips. It's an online application. It's quite easy, but in your application, you should emphasize where the grey areas are. Okay, where the area of dispute is. And if you can point out where the grey areas are, that is more likely to get your ADR application accepted. Preparation meeting is essential with Mr. Orange, with the taxpayer, because both of you need to be briefed. He needs to be briefed on the area. He needs to have a clear understanding of his tax dispute, because we have situations where the taxpayer doesn't understand what's going on. So they need to understand what is the point of tax dispute, and also just to prepare them for the meeting. It's very intimidating for taxpayers to come in these meetings and face HMRC. So you need to assure them, look, the flow will be under our control. The mediator is there. Whenever we want a break, we can take a break. There's nothing for you to be nervous about. We will be there. So it's just prepping them factually and mentally for the meeting. Because the meeting, the caseworker face to face, maybe for the first time. And the whole point is it's not an adversarial environment. It should be a collaborative environment. The third tip would be the opening statement. When you submit it, please keep it simple. Mine is never more than half a page. I've never needed to write more than half a page, because it is what it is. It's an opening page. It's an opening statement. You're going to be discussing all the points at issue throughout the whole process anyway. So you just need to put the bare points. In fact, go to your online application, see what you've written there, and copy and paste and put it in your opening statement. So you're not duplicating work. You just need to do half a page. It doesn't need to be any more. And I guarantee you, HMRC will always come with a minimum of 2 sides to their opening statement, and everything will be their chronological order. Because I don't think they got the understanding yet. It's an opening statement. It's not a summary. The whole point is to explore it. During ADR, please be proactive. Don't be passive. Use your mediator. Don't sit in the room and not. Because they're going to break you out in separate rooms after the meeting, the initial meeting, and opening statements. Don't sit in the room and just expect the mediator to do all the work. If you think there's an area that can be explored, you can say to your mediator, could you just go and test and see, if HMRC is receptive to this, and you can proactively use your mediator in that way. If you sit in the room and expect the mediator to do all the work, it's, the possibility of failure is higher as a result. Keep trying even after the exit agreement if a resolution has not been reached. Don't give up. And so if you think, even your exit agreement, as I said, if you think there's additional areas like, okay, let's submit, we haven't reached a resolution today, but if we submit this and this document, then you will consider it and we can go further. You can put that in your exit agreement, and that is a way forward. So even where you haven't reached a resolution, there is a way forward from that. And even if you think, okay, we've not reached an agreement on this, we haven't reached an agreement, we're going to end up going to tribunal. You can still narrow down the facts, the statement of facts. You can agree and disagree and narrow down the dispute, which involves less work when you go to tribunal. The other thing is, because Jim was saying this yesterday, that the furlough schemes and job retention compliance check will also be included in the ADR process as well. They will be considered. So that is a good point to go forward to. So Jim, do you have any tips to share?
I think, to be honest, the whole main covered here, it is about collaboration. That is what I would say, and it is openness on both sides, because the mediator will work hard to get a resolution if possible, but again, in order to get a resolution, both sides have got to be open and consider the arguments being put forward. I think there's just been a question there with regards to policy, and again, I'd say that when HMRC could consider any proposals providing they are LSS compliant. So if it was in the scope of the LSS, then yes, which is why we make sure, or we should have as far as possible, the decision maker and indeed a manager or somebody who can okay the agreement there. But for me, it is a collaboration point of view. It is work with the mediator, and the mediator will work with both parties, and a lot of it is just about listen as well. One side might be very upset with the other side. What we don't want, and little things like body language. There was a mediation the other week when the two HMRC sides spoke. The accountant burst out laughing and just tutted all the way through. That's not really collaborative working. We've also seen from the HMRC point of view where a taxpayer has been speaking, the HMRC officer is just there shaking his head. That isn't going to help move the case forward. So take the step back, work collaboratively, and that way there's more chance of getting a successful resolution.
And it is a skill set that you do need in getting a successful resolution, and that's why mine, I think, has been higher, because having that ex-HMRC perspective and the ADR perspective, so I know straight away I can understand the risk, the approach of the HMRC caseworker, and I can understand the role of the ADR mediator, what they need to do in order to reach a resolution on the case. And that's why my perspective on it, so I can bring in the LSS, and I can say whether I think they're being reasonable and unreasonable, because I have tribunal experience and I have stood before tribunal judges and have had to put my clients' side of things across. And believe me, you want to have a consistent argument and line all throughout the dispute, including when you're interacting during ADR. Because and this is something that I know mediators have put across to HMRC. These are questions you have to be answered and explored. And if you can't do it at this stage, then how are you going to do it at tribunal? So they are challenged, because the mediators do have that tribunal training, and they know what they're going to be challenged on. Okay, so we have a comparison. If we compare the statutory review and ADR, the difference. Statutory review is a statutory right and will be offered by HMRC for tax or penalty decisions, and it's for the client to accept. So ADR is a voluntary process for the client to apply for, or the agent to apply for. ADR cannot be applied for every case. It has to be suitable for mediation. So you've got one where it's a statutory right and one where it's a voluntary mediation process, and that's the whole point. The mediation has to be voluntary. Although for HMRC it's not, because it's compulsory. Once the ADR application's been accepted, it is compulsory for HMRC to attend. All parties have to be actively involved and engaged with ADR. The statutory review is a one-way review process with limited active input by the customer. So unless you put a representation in, even that can be quite limited. And there's been situations where a representation has been put in or additional information documents have been provided, but hasn't been included in the statutory review. But when you come in the ADR process, all of that is put on the table and all of that is considered. So the decision is with the statutory review officer, but for ADR, the decision is with both parties. And for tribunal hearings, the decision is with the tribunal judge. So what are the common areas? Well, I think for both, on the customer side, the customer still doesn't sit very comfortably with us, Jim. Taxpayers is a better reference for us. But there is the issue of independence. So there is this idea of, is the Hmrc review officer independent? Is the ADR process independent? And I think you will always have those questions coming up. But it's good that on the ADR side you have the external feedback and input to see, because the day when the issue of independence is really doubted, I think is the day when ADR is not going to be very popular. But as long as you can show that in the stats and you can show that in the statistics, that over 84% is resolved, then and successful. And I'm definitely someone who endorses ADR all the way through. So the statutory review and ADR, they don't affect the appeal rights. And the other thing was the effect of COVID-19, because both have had it extended, the time limit. The 3 months time limit, although I'm not sure. What has been the impact for COVID-19 for ADR, Jim?
To be honest, typically my screen has just gone blank when I have the stats in front of me. We did have a drop in the number of applications, which isn't really surprising, seeing Hmrc put the pause on the compliance activity in the summer of 2020 due to COVID, which essentially took a quarter of a year's worth of potential cases out of the mix while they're on hold. So in the year, we've had a 16% drop in applications. However, for the last 4 years, from November 2020 through to April 2021, we've actually seen an increase of about 5% compared to the same period in the previous year pre-pandemic. So I think we've come through this stronger and we are now actually growing again. Our resolution rate is still at 82%, which is pretty good considering we've not had a single face-to-face case at this moment in time. What has happened is that last year, where the main effect has been, is that we were clearing around about 88-89% of cases within 120 days. This has not surprisingly dropped to 79% within 120 days. But you're still looking at 3 out of 4 cases are work and settle within a 120-day period. And the main reasons for the drop is, of course, furlough, people being adversely affected, people having to work from home and such like. So I think that, yes, there has been an effect on us, but it's not been as major as it could have been because we've changed the working practices to try and deal with it as much as we can, and I'm still pretty proud that the figures are still so high after getting strong awful 14 months. We're just still in, I suppose we could say, but hopefully coming out of.
And because I've actually been asking the questions that have been put to me by other people. Sorry, Chris.
Yeah, it was just one thing. I know we're very close to the time now. In the litigation settlement strategy, page 24, it says it is important to distinguish a fact from a belief or an assumption.
Yes.
Now, Jim, it's a bit of a loaded question, this, but this is the biggest problem I come across all of the time. Is it a high percentage in your cases?
It is a difficult one, and we've had such. I'll be honest about this. Both parties to the mediation in what is a fact, and people's definition of a fact isn't necessarily what mine is, because I've seen too many assumptions being seen as facts. Here are facts. That's not a fact. That's not a fact. That's an assumption. I run a business. That is a fact. It could be said, but then if all of a sudden somebody says, and this business was taking X amount per week, well, and X amount was being taken out as undeclared takings, that's not a fact, that's an assumption. And I think for both parties, there's a lot of work that needs to be done in actually getting the definition of what a fact is as opposed to an assumption.
Chris, that we could do another webinar on it. And yesterday we thought we have to be careful because we could easily do another webinar on the appeal process. There were so many areas we really have to limit ourselves in the webinar, keep strictly to the content of the webinar, but we could have quite easily done more than half a day on all of this. Statutory review and ADR. So we really had to limit ourselves. And so with the ADR questions as well, because it's not been in the chat room, but I have actually been answering the questions that have been asked, and that's been emailed to me throughout the whole process. So thank you very much, Jim. There's just one more thing I just want to put across. I don't think we put across it clearly. Is ADR can be applied for at any time before tax assessment. So it can be applied at any time, whereas a statutory review can only be offered when a tax assessment has been issued. So I just want to put that fact across.
Yeah. If I could just add to that, the majority of ADR applications come once an appealable decision has been raised. There are reasons for this that I've looked into that I won't go into now, but we do offer ADR at any stage an impasse has been reached during the compliance process. At any stage.
I want to thank you very much, Jim, for your valuable contribution, and thank you very much, Chris, and thank you all for attending as well. As a thank you, we will be sending you ADR guidance, which will be quite detailed, and I will offer also a 15 minutes free ADR consultation. You need to email me for that. Please complete the feedback provided in the chat box. It's been really good to have you all. A lot of you probably I'm seeing for the first time. Well, I can't really see you, but thank you for attending from those from LinkedIn and so on. Thank you very much. We are now going to open the room on Clubhouse. So you'll feel free to drop in on Clubhouse if you want to ask me anything. Okay.
That was excellent. Outstanding. Real passion.
What's that Facebook? You just went.
No, Facebook is still there, and
Thank you very much.
We'll close up, but brilliant. Absolutely.
Gary, what happened there? Something just went.
Nope, that was me changing the.
Thank you very much, all.
That was me changing it. So we'll call this a day, but don't forget there is something if you email, and you can watch this, you can share it, you can ask for. There you go. Still on mute. Well done, Gary. Look, such passion, such brilliant stuff. And don't forget, you can watch the rewind. There was a lot of information here. We'll put the copy of this out there. Fantastic. Now you're on mute.
Am I on mute now?
No, you're not on mute, Chris.
You keep muting me. That's why.
Well, hands are there.
How did you enjoy it, Jim and Chris? Both of you. Did it go okay?
I think what it does is improve the perceptions from both sides. I think that's really, really important because we've no longer got back in the days where we used to have inquiry points and call-in points. And I think people miss the interaction. And I think that's a bit of a problem when you get cold letters and emails. Just my point.
I really enjoyed this, and I like the thing similar because one thing that has always been not a bugbear, one thing I'm hung up about is the independence, which is why I do a lot of presentations. I think the most scary ever was with a barrister. We had to do an actual on that webinar with the green screen and everything live from our in front of TV cameras and everything down in a proper TV studio. That was exceptionally scary. So after that, everything's fine. But it's good to get the feedback because we're always looking, is everything perfect? 100%. We can always improve things, and the best way to look to improve things is to take on board the feedback and listen to what people are saying. Because if you don't do that, things will never change. So I think it's really good to have these discussions, which I continue to do. In fact, I did a breakfast seminar last week with Kevin Igo et al. So I found them really, really useful, and I thought this one went really, really well.
Yeah, the last thanks should really go to you because you've put in so much work. All those slides, all the things that go on in the background. You've really dedicated yourself. So thank you very much.
No, you're welcome, Gary. And as I said, when we spoke yesterday, I mean, I could have easily done another half an hour actually today, but we had to restrict ourselves. I mean, even now I'm thinking, we should have meant the confidentiality about the exception when there's a complaint and so on. I was thinking and mention fraud investigate, but you can't include everything. But that's why we do what we do. And provide additional webinars and share additional information and so on. That's why we do what we do in order to get that information out there. I really enjoyed it a lot. Thank you, Chris. I feel like if this we should go off to a pub or something and then have a chat. But we can't even do
Absolutely.
that yet. That's what I feel like.
It's freezing outside. It's been hailstorming down in the northeast of England. So I would love to go to a pub, and that's what we used to do back in the days.
Yeah.
So once again. Yeah.
And on to the next one. When is Clubhouse? It's in.
Clubhouse is actually supposed to be on now at 6 o'clock.
So I'm gonna have to escort you over there. Everyone have a lovely evening and a safe evening, and it's been brilliant.
Thank you.
Really enjoyed it.
I'll call both of you afterwards and we'll discuss afterwards.
Well, how about talk about it on Clubhouse?
All right then. Okay.